Joining us now from our Abuja studios to discuss the Supreme Court's decision on David Lyon's petition dismissal is Professor Isaac Nnamdi Obasi, a professor of public policy and state labor industrial relations in the Department of Public Administration in the University of Abuja. Welcome to the morning show. Thank you for joining us. Now, I mean, we do know the details of this petition dismissal, and the first question I want to ask you now is about this 30 million naira fine. Now, do you think that this fine would be a deterrent to the legal team that represents these politicians, as well as the politicians, in the case where the Apex Court has come out to say that it was frivolous to even bring it back to the Supreme Court to start with?
Thank you very much. The matter calls for sober reflection and analysis. I must say that there is need for deterrent. There is need to sanitize the judicial process. There is need for very senior lawyers, the best of our best, be in a vantage position to advise their clients of cases that really have merit, and not, and not going into the court for frivolous and annoying or vexatious reasons that can provoke the anger we saw yesterday. The delivery by Mrs. Judge, our Chief Justice, our Justice Amina Augie, was vehement in stating clearly that she feels pained, even with tears in her eyes, that senior lawyers will bring back this kind of thing. So 30 million, is it only 30 million? If you check the number of people and 2 lawyers, it may be 60 million. And it will be going 10 million to the respondents. And that's to some extent a good deterrent. But it depends on who is paying. If the person who is paying has enough money, may think it doesn't matter. But in this country, I think we need to sanitize the system and encourage non-frivolous cases. There may be cases that may warrant being tested.
Okay, let's look at this case now. There may be cases that may warrant being tested. Are you telling me that these two, can I use the word doyens in the Nigerian judicial and legal system, didn't see a particular loophole in their arguments to bring forward and test it out in court in terms of a review? Well, Elanibaku, for instance, correct me if I'm wrong. I was saying before we came on the show that his win rate in the Supreme Court should be over 70–80%. This is about the only time I've heard that anything for Elanibaku has been pushed away in the Supreme Court. Are you saying they didn't find a loophole? And the likes of Afe Babalola at close to 90 years of age, or 90, coming back to the court again.
Lawyers will always look for a loophole. Even if there is none, they think of technicalities to see if they can succeed. I don't know the psychology of senior lawyers in taking some cases to the courts, but I do know that some of the cases that are lingering over the years, you might think the senior lawyers are there to stamp the authority over all those who may be justices of the Supreme Court, but are by far their junior. And in one word or other, they can also raise their intellectual capacity. But I don't want to think definitely that's what's at stake. But our judicial process needs sanitizing. So whether you're a senior lawyer or junior lawyer, the issue of using technicalities at times, which you know, to make a case drag endlessly, sometimes 10 to 15 years or 20, is unacceptable in a very decent and civilized society.
I want to get your opinion on this, because when Justice Amina was reading that judgment yesterday, she said, and let me quote from what she said. She says, if we review this judgment, every disaffected litigant will bring similar applications and the finality of Supreme Court judgments will be lost, end quote. Let me ask your opinion. Is it a case of, if we do review this, we open the floodgate to frivolous applications for review, or we dismiss this case because, you know what, we are the final arbiter?
All of them. all of them. The case is this. We are not talking about they took the substantive issue for granted. They believe that what they are saying are obvious, that it shouldn't have come to them. That's why they use the word frivolous. That's why they use the word vexatious. That's why they say it's a gross abuse of the court process. So they are assuming that the merit of the case lacks merit. That's what they are assuming. But they are not just saying, okay, we dismiss it, we don't want to open a Pandora's box, a floodgate of cases. People will be bringing something that ordinarily should not come back. That's not what they are saying. But I could say both, because when you open a Pandora's box, definitely Tom, Dick, and Harry will come in. But let me still say, it does not and will not deter any case that is seen to lack merit before the Supreme Court. And if the case, anybody who feels justified, who feels they can challenge it, they can do that. The window may be narrow, but they can challenge it. The Supreme Court has reviewed itself before, although we are told in rare cases of nullity of the substantive, the merit of the case, cases of fraud, cases of clerical errors and omission and etc. But we have not heard of cases of mathematical error. So if there are cases that warrant review, let them go and test it out. But the deterrent is good. So we don't want Tom, Dick, and Harry go and harass our Supreme Court. They are very busy. And that is why, if you remember, the case was made during clearance of ministers that, in fact, we should decentralize the Supreme Court into 6 zones, with the highest one, the one at Abuja, looking at issues of highest importance and of constitutional matters. So Supreme Court people are very busy, that they cannot and should not be diverted with frivolous cases. So on both sides.
Okay, very good recommendation there as regards zonalizing the Supreme Court. And I just wanted to pick on that because it was currently the deputy or the Minister of State for Labour, that's Senior Advocate of Nigeria, Festus Keyamo, that made that opinion while he was going through his own ministerial screening. So somebody will think that isn't time for the Judicial Council to start even thinking of things like that, because everybody, can I use the word, if it sounds a little bit crass, forgive me, every Tom, Dick, and Harry goes to the Supreme Court these days. And that has impeded on the dispensation of justice in this country. Should we start looking at that as an option now?
Oh, yes. We should not judge because Tom, Dick, and Harry goes. That's why we should, decentralize. I guess that's what you are saying.
Yes. Yes.
Okay, good. For sure, the volume of work is enormous. The volume of work is enormous. And let me say it. If you are a lecturer marking 500 scripts within 2 weeks, my dear, single-mindedness is the issue. You have to be there doing it. And if you are distracted with other things, you may make mistake. That's the case with the Supreme Court. They are human beings. And nobody says they are not infallible. Nobody says so. And if that is the case too, that means that as human beings, they might, even out of 1,000, make a mistake. That one mistake needs to be corrected. Because a court of finality needs to be endowed with that honor, respect given to it for what it says. Should not be just final, but seen to be finally correct, proprietary, procedurally correct, and seen to be gaining the respect of Tom, Dick, and Harry now, not Tom, Dick, and Harry that runs to the courts.
Definitely. Let's talk about the concept of these judicial reviews, because we do know that we have a lot of these pending cases. According to Section 235, Order 8, it says that obviously the Supreme Court shall not review itself except for certain cases where there is misinterpretation of facts, where we have a case of jurisdiction or human error. Now, we can't help but also look at the case that is happening currently now in Imo State. What does this mean for our elections, our democracy, and the judiciary system as a whole?
naturally, the doctrine of stare decisis requires that precedent set should be obeyed. But that same doctrine, too, allows distinction to be made. You cannot, but a lot of lawyers do this mistake. They rush to the court, oh, it's the same case. Unless you have the facts of the matter, the details, you may not know whether two things are similar. If they are similar, the Supreme Court will be in a position to know. Imo case, for me, that was a mathematical error. If INEC was to judge with that kind of evidence before it, it will order, it will say, oh, there is a case of indecisiveness. The election is not concluded. That's what it will order, and they go back. But this is Supreme Court, here we are. This case has been judged that way. So, in its wisdom, it can reverse itself. Nobody is infallible, and Supreme Court is not.
Indeed, and the Supreme Court as well is not an appeal court where everybody can just run to. But let me talk about the lessons here, because we do know there are pending reviews. In fact, IMO was adjourned to the 2nd of next month, and we do hear threats from the political parties that they are going to approach the Supreme Court for others, including the presidential elections. But what are the lessons here, if any, for political parties and politicians? We might need to go on a break very soon, so I don't know if you want to start to respond to that, or we'll just go on that break, and we'll be right back for you to respond to my question. I think we should go on that break now, and then we're back to talk some more. Stay with us. Thank you so much for joining us. You're still watching the morning show here on Arise News, and we'll have from our studios in Abuja, Professor Obasi, who is helping us to review yesterday's dismissal of the APC's appeal for review in the Bayelsa governorship elections. Thank you so much, Professor, for staying with us. My question before the break, what is the lesson here, if any, for the political parties and politicians in general? And bearing in mind that we also have that pending IMO situation at the Supreme Court, and we have threats by political parties saying we will take to the Supreme Court, including the presidential election.
Actually, that's the Pandora's box situation. What the Justice of the Supreme Court called floodgates of applications yesterday. Opening a Pandora's box is not a good thing to do at that level, even at a lower level. But the cost awarded yesterday is to be personally paid by the lawyer. Personally paid. So all those political parties, they all have their legal advisors. And if they want to go and hire lawyers for a case, they may think they have merit, even when it is not. Let them go. They get the same cost or even more. And I don't know whether justices and judges look at people before they slam you a cost. But I do know that doctors charge at times discriminatingly according to social class. So if there is also applying social class in their cost award, those people, when they come back, they may get more. Yeah, the gubernatorial and presidential will be different in the cost award, I guess. But that apart, saying cases like I said, IMO, I don't want to say, okay, this is the merit. But I say, even a primary school person will know that the number that came out is more than those who could have ordinarily been accredited. If that is the case, there's a mathematical error. Whether it's human error, I don't know, but it's not clerical error. Whether it's error of omission, perhaps the justices are in a position, in their wisdom, to decide the case. I support that case to be tested. Nobody should go and withdraw it. I had people this morning saying, oh, those are IMO people, they should go and withdraw it. No, it should be tested. Because what we saw was a brazen case of error.
Okay. If you say it should be tested, that means if it goes this way too, then they should be ready for a fine too, because, I mean, the fine is a standard for everybody. But I just quickly want to ask this, and I want to dial back to a report released in the late, about 2009, 2000, after the 2007 elections, Ways report. I was talking about a special court for elections. I mean, lawyers and every pundit out there comes here, and the first thing they say is, electoral petition is sui generis. It's in a class of its own. Why can't we have a sui generis court that makes this decision once and for all, that you can't review, that makes the process quicker and faster, rather than still taking it to the Supreme Court that is burdened with all the civil and criminal matters?
I am on the same page with you. The point you made is quite correct. Not only this country, I think we have, for issues of labor now, a labor court, you know, National Industrial Court. So you can have specialized courts, and they exist elsewhere in other jurisdictions, even administrative court that handles administrative law. You have a highest court that handles that in some countries. So it is not a bad idea if we save our justices that kind of frivolous applications coming to them. We can do that. We can create specialized. The concept of specialized courts are even here with us. That's the point. So nothing is bad about doing that if they cannot decentralize.
I mean, also, I want to bring it back to this fine that you said should be a huge deterrent in making sure that frivolous cases are not filed. In a case where we have these lawyers who have seen a reason to take it back to court and have the legal obligation to defend their clients, don't you think that maybe this is a bit too harsh? And also looking at the fact that these politicians did push for this case to be taken back to the Supreme Court, shouldn't there have been some kind of fine or some kind of punishment pushed to that party as well?
Did I hear you say legal obligation? They don't have. A lawyer is hired. It's not a legal obligation. You can enter a contract with the lawyer who is going to appear on your behalf. So it's not compulsory that a senior lawyer must take a case. Do you know whether they had approached some other senior lawyers who said, no, I don't see merit in this case, before those who agreed? So that's a different matter. So I don't think it's a legal compulsion for any lawyer to accept a case. You see, being very senior means that theoretically, practically, they are superior in their thinking. They are superior in their presentation. They are superior in their historical analysis and analogies. They are superior in many respects. And if they are going there, they are expected to have seen if there are technicalities, if there are loopholes. If there are none, they spare themselves for such embarrassment. But if they decide to go, so be it. The courage of their conviction is that I must take this case on. They should be ready to take whatever comes out of it. And in any case, this cost must be paid.
Indeed, Professor Obasi, just looking at the points from the judgments yesterday read by Justice Amina, which we have used some of those phrases. I mean, it lacked merit, it was vexatious, it was frivolous, the Supreme Court is final. What was most striking for you in all of this? And would you say that the Supreme Court has done anything new, really, by this judgment?
Quite a good question. I think the doctrine of functus officio, which was invoked yesterday, that doctrine requires that whether a panel, whether a single arbitrator, whether a group of judges who handle a case, that when they finish handling that case, they cannot just come within a space of time to review themselves, that it is final. The grantor and the receiver, they know this, and they're on the same page of what their right is. And that this is done in furtherance of justice, fairness, and certainty in law. It was also emphasized yesterday that what they want to do is to guarantee certainty by allowing Supreme Court to be the final bus stop. Final bus stop. That's what they made this case clear. So that doctrine of functus officio is a lesson for lawyers. But it will not deter completely when any of them sees a loophole, an error that can be challenged. Like I said, Supreme Court is made up of judges who are human beings and who are infallible. No, who are not infallible. So any mistake can be made, and if in their conviction, in their own conviction, their own wisdom, they see that merit in that and there was a mistake, I think they'll be humble enough to review it.
Okay.
Hello?
Yeah, this one, we just has a follow-up to that.
Professor Obasi, I was just going to mention, you know, it's very scary somewhat to say, just to buttress your point when you say deterrence, but you also mentioned earlier that it depends on who is paying this amount. If I can afford 10 million naira, I probably will commit the same offense over and over again. And then you've talked about, you know, lawyers always finding loopholes because that is what they are. They are lawyers, and they look for loopholes to explore. Would you really say that this whole issue of deterrence, the Supreme Court has been able to, you know, reassert itself as that final arbiter? Are you confident that this is what has happened with with the judgment from yesterday?
Yeah, what he did yesterday was to restate an obvious fact, which we know. It is final. It's the last bus stop. That's what he did yesterday. The cost it awarded, definitely, can deter people. But like I said, if people think a case has merit, and they're buoyant enough to go and say, if I lose and I'm awarded a cost against me, I can do it. I've satisfied my conscience. So will be it. Let them go and test it. But Supreme Court has said yesterday, which definitely everybody knows, that this is the last bus stop. They always, if you say, some people say, oh, it's only God. Yes, but Supreme Court knows also there is a window. That window is not for frivolous cases, not for vexatious cases, and not for a case that can constitute a gross abuse in the judicial process. No. If there are real cases of error, I am not here to say this is it. But I pointed one I know that's mathematical. We can calculate that, and we can see it. In logic, yes, we can see it. But we are saying that it's the Supreme Court, too, that will have the humility to correct itself. And if it does, it will win accolades. It will get more respect.
Okay, Professor Obasi, real quickly, because we're wrapping up very soon, I just wanted to ask you this. Who is to blame here? The overambition of politicians, win at all cost? The integrity of the Supreme Court, which has been questioned recently, or the love or the, passion to interpret the law by lawyers? Who should be blamed here?
Everybody, but let me prioritize. They put it in a higher ascending order. You see, politicians must take 65% of the blame. We are left with 35%. The judges, the justices, will take about 30%. We are left with 5%. You can award that to any. Why am I saying so? Politicians are desperate in this country. I've said it clearly that if how we see politicians are the ones that are trained in the universities, nobody will send his child to read post science. That's the point. I've made this point repeatedly. They do not represent what can be the fineness of knowledge, the values that they should promote to make a political system civic and respectful. They do not respect the rule of law. They are violent. They kill. So if all these things are together, they should take...
Thank you so much, Professor Obasi.
They take much of the blame.
We do appreciate your appearance today on the show. Thank you.